Dear panelists and registered participants, dear colleagues and learned friends, I am truly delighted to welcome all of you to this rather socially distanced launch event for the publication of Advancing Victim Participation at the International Criminal Court, Bridging the Gap Between Research and Practice. I was rather pleased to learn this morning that around 100 of you had registered from all over the world to tune in, which is the maximum attendance we could have on this virtual platform. And for those who could not join us live, this event is being live streamed and will be recorded and will be uploaded on the websites of the International Criminal Court Bar Association and the website of the Oxford Faculty of Law. I'm joined here today by my colleague and co-editor of this publication, Gregory Townsend, who is a chair of the ICCBA Legal Advisory Committee and a lecturer in international law at The Hague University, by Professor Caroline Hoyle, a distinguished professor of criminology and former director of the Center for Criminology at Oxford, as well as my former academic supervisor and colleague, by Peter Haynes, QC, the president of the International Criminal Court Bar Association. Also, we are joined by a number of authors whose contribution to this publication has been truly immense, and I would encourage them to participate in the discussion part of this event with their insights and perspectives on victim participation. In terms of the format, we will proceed with the first 25 to 30 minutes with the remarks by myself and the other three panelists, and then we will open the floor, this virtual floor, for discussion. And I would invite you to send questions in the chat. And Dominic Kennedy, who has you, and if you want to speak, please. You could ask or write that in the chat box. This publication marks a finalization of a very successful collaboration between the University of Oxford and the International Criminal Court Bar Association on a topic that has been not only the center of my research and intellectual interest, but has come to define as a theme the current trend of development in international criminal justice. Justice for victims has been called the rallying call, or let's say the raison d'etre for international criminal justice mechanisms. This noble goal has been at the very heart of the work of all ad hoc hybrid tribunals, as well as the International Criminal Court. And yet criticism has been leveled at these tribunals for not doing enough for victims of mass atrocities. The main challenge, in fact, lies, I believe, in the ambiguity as to what justice for victims means and what form it could take within international criminal justice. Understanding the scope and impact that victim participation could have in the trial process on the right of the accused to a fair and expeditious trial, as well as on the rights of victims themselves, has been an issue with which all tribunals have struggled with, and the ICC especially. Compared to other tribunals, the development of the application of victim participation at the International Criminal Court has been more horizontal and decentralized in nature by virtue of having a number of cases within each situation. Each pre-trial and trial chamber has had to demarcate the boundaries of victim participation according to their interpretation of the role that victims could play, as well as the requirements of each specific case and each specific situation. But more broadly, it is important to understand that victim participation at an international level, which is to some extent different or differs from the application of victims in domestic criminal justice systems, by virtue of having subject matter constraints, the nature of the conflict, mass victimization, in many ways showing the difference between domestic legal system and international criminal justice system. In this context, the application of victim participation at the International Criminal Tribunals have posed some very specific questions, which in turn have given rise to complex answers and challenges. Undoubtedly, victim participation is still in its nascent stage, and its sui generis nature has to some extent characterized its whole application in practice. The research to date has shown that there is a critical need for well-developed standards, both at the normative and legal level, but also common standards of practice, to facilitate the application not only at the ICC, but also all other tribunals, as well as tribunals yet to be created. This was indeed confirmed also by the findings of my own research with victims of the Khmer Rouge before the extraordinary chambers in the courts of Cambodia. And it shows that while victims may, in principle, have some form of realization of restorative justice, in fact, the manner in which victim participation has been crafted and interpreted at the extraordinary chambers in the courts of Cambodia, the International Criminal Court, the Special Tribunal for Lebanon, and yet to be seen how it will be applied at the Kosovo Specialist Chambers. One thing is for sure, that victim participation has indeed had to some degree an impact on the functionality of court proceedings and on the rights of the accused as well as the rights of the victims. With development emerge, and with the view to advancing the impact of victim participation at the ICC, the Center for Criminology at Oxford and the International Criminal Court Bar Association embarked on this joint project with the aim to develop a platform for knowledge exchange, but most importantly, to designing resources for the education and training of legal practitioners at the ICC, and more specifically, legal representatives for victims at the ICC. In this context, over the course of the past 2 years, we organized 2 events, one at the ICC on 31st of May and 1st of June, a workshop and a training, a 2-day event, which brought together distinguished scholars and practitioners, as well as many members of the ICCBA, who engaged in a lively discussion on various aspects of victim participation. On 4th October 2018, we held another event, an expert workshop at the Bonavero Institute of Human Rights at Mansfield College in Oxford. This was an expert workshop that offered an opportunity to all the participating panelists to talk about specific aspects of victim participation, such as reparation, issues concerning psychological and ethical considerations of receiving impact, or let's say the testimony from the witness, both as a witness for the prosecution, but also as a witness, as a victim participant. This publication grew out of this collaboration. This was the impetus that gave an opportunity to us to consider whether it would be truly valuable, and I believe it will be truly valuable, to have a publication that will continue to inform all those who engage with the topic of victim participation and to offer them up-to-date knowledge of the current theoretical and jurisprudential development of victim participation. In this light, this publication, we hope, will be beneficial not only to the legal representatives of victims, participating victims, as well as will be really beneficial to all those who engage with the topic of victim participation. Furthermore, I would say that I consider this publication important in light of the new trend in international criminal justice, where all tribunals that have been established after the ICC have incorporated some form of victim participation. And it is fair to assume that any future tribunal that may be established, be that ad hoc or hybrid tribunal, to address specific conflicts around the world, will include and will incorporate some form of victim participation. I will conclude my remarks with an expression of gratitude for all of you who have contributed to this project and to this publication. First of all, I would like to thank Professor Caroline Hoyle for supporting the idea of this project from day one, And I am truly honored that she could believe in this project and see the value that this publication will hopefully offer not only for the ICC, but also in terms of the development in international criminal justice. I would like to thank Gregory for his outstanding contribution to the publication and for being a very meticulous editor. And I couldn't ask for a better editor to work with, as well as like to thank all the colleagues at the ICCBA, Peter, Dominic Kennedy, Jens Dickerman, Paulina Macida, Luis Galen, and all our contributing authors. Thank you very much. And I will give the virtual floor now to Gregory for some of his remarks. Thank you.
Thank you, Ina. It's been a real pleasure to work with you and with everyone, and I just will echo all those thank yous, and we owe so much to all of the contributors and those that have supported us along the way, so thank you. What I'm wondering, and if you could chime into the chat if any of the authors are with us today. The authors include Megan Hurst, Sandra Sayuni, Paulina Macida, Nicole Sampson, Carla Firstman, Luc Valen, Lorraine Van Smith, Anne Michel, Ellie Smith, and Sarah Kendall. If any of you there, please chime in. What I've written in my concluding remarks includes a short blurb on all of the articles, and perhaps to entice you to read more, I'll give you just a quick line on each, and then turn over the floor. And I have to apologize if my internet connection is so unstable today. Didn't have any until just a few minutes ago. Megan Hurst and Sandra Sayuni's articles first, and it really talks about how to make legal representation for victims more effective, and offers a really interesting comparison to defense counsel effectiveness and measures to do that. And they propose increasing maybe establishing professional guidelines, in establishing more effective tools, and a very meaty piece that's really worth a lot of study and comment. Paulina's here. Can't see you. Laura, if you can still stick around, I won't paraphrase your article and let you chime in for yourself. Nicole Sampson's after Paulina's article and talks about dual victim witnesses and how that special status plays out, and she talks us through all the case law, and really excellent practitioner's article. Carla Firstman talks about human rights approaches to victim participation and reparations, and brings a wealth of experience in her role in redress and her present academic role into that post. Briefly, Luc Valen, who's been doing victim participation since Lubanga and still is doing victim participation since in Lubanga, talks about reparations and walks us through the case law and the challenges practically that, and focuses particularly on collective reparations as opposed to individual reparations, and how that's really new precedent law here. Lorraine Van Smith focuses on sexual and gender-based violence, those crimes, how they've played out before, and how the Ntaganda trial conviction represents, in her eyes, a really important opportunity for us to use the existing tools of reparations for those particular victims, and an amazing opportunity to play out. Michelle's works in the victim and witness section at the ICC. Oh, hi, Anne, welcome. I'll let you address your own. And what I like so much about your article is how you compare the attorney-client relationship to the psychologist-patient-client. And I think you say the lawyers need more training is your first recommendation. And I think you're right. So I'd like to hear more from you. Ellie Smith's article talks about trauma, how it affects victims, how it affects their testimony, and how courts have to really take that into consideration when they're weighing that evidence, in particular indicia of credibility. In the last article, Sarah Kendall really has an interesting approach on how making people whole and reparations and restorative justice is intersecting for the ICC with what is traditionally a justice system that's worried about retribution and punishment, and what she calls the juridified victim. And I think that provokes a lot of thought and conversation. And so that's a really, in a nutshell, very brief sentence or two about each. And it's been a sincere pleasure to learn and read these and add a few comments here and there. So thank you so much. And happy to turn over the floor. Returning it to Professor Hoyle at this point. I'll put it in your hands. Thank you so much.
Thank you, Gregory. Well, first of all, I really want to just congratulate Redina and Gregory for this really excellent publication. Those of us who've edited books before know that the reputation and the quality of an edited collection stands and falls by the consistency of the presentations within that publication. And this is a consistently good collection of essays that have been very well edited. So really well done on that. When I was first thinking and researching victim participation in the criminal process, it was over 20 years ago. I was doing research on victim impact statements, which at the time had been newly introduced into the UK. And I was very aware of the potential for both significant benefits, but also for the possible pitfalls of giving victims a voice in the criminal process. So then the idea of victims having a meaningful role to play in the state's response to crimes against them was entirely novel, but the world has obviously changed considerably. And now, while we must all be mindful of defendants' rights to fair and impartial hearings, it would seem, I think, unfeasible for any criminal justice system not to make room for victim participation in some form or another, particularly at the International Criminal Court, where victims have experienced, of course, the most serious of crimes and the most significant of harms. And it seems to me, looking at this book, the chapters really all address all of those important issues that I've tried to address in my own research on the local level. And also that I try to address in my teaching. So next term I will teach the course that I teach once a year at Oxford on victims. And all of these issues covered in these various chapters could very well be given at different parts of that course because they all speak to what's at the heart of this issue. So really well done. Of course, the other thing that's changed considerably over the past 30 years while I have been an academic is the expectation that academics don't just do research and write for other academics, as I think we used to. So within the social sciences, especially in my discipline of criminology, we have been in past years encouraged very strongly to work closely with criminal justice policymakers, professionals, charities, and those that run, participate in, and make use of the criminal process. And we're expected to collaborate and engage not just in disseminating findings of the research that we've thought up ourselves, but at every stage of the research, from the inception of ideas right through to efforts to ensure that research findings can make an impact on the communities and the professionals that we work with. And the Centre for Criminology and Oxford as a wider institution has long valued and supported projects with strong impact arising from excellent research. Such as the research on this novel development in the field of international criminal justice. So I applaud this project for doing just that too. So you see in my academic lifetime so far, 2 changes to the field of victimology and to the methods and the practices of the discipline of criminology can be seen to have reached fruition in this very important project. A collection of essays from both academics and practitioners that has been fully collaborative right from the start and that focuses on victim participation in arguably the most important court in the world, at least in some respects. And so that's why I feel exceptionally proud to have played a very small part in this, though of course the credit for the realization of these goals goes squarely to Redina and to Gregory. So as Regina made reference to it, the publication really marks the finalisation of a successful joint project with the International Criminal Court Bar Association. And our collaboration has been, from the way I see it at least, very positive. It's been characterised by a shared vision of co-design resources for the education and training of criminal justice practitioners. It's drawn from both theoretical and jurisprudential developments on victim participation, as well as created this platform for exchanging knowledge, all the things that we're meant to do these days. And the project, of course, as Regina mentioned before, developed really from collaborative work that we've done together, and we've both published both theoretical and empirical research in the field of criminal justice and victims. My own work has looked at restorative justice for the past 20 years, as well as other areas of victim participation. And Regina's study has centred on the scope, the role and the implications of participation of victims of gross human rights violations in international criminal proceedings. So she mentioned that she did this in-depth exploration of the extraordinary chambers in the courts of Cambodia and the International Criminal Court, and that was really fantastic work. I'm very proud of her for achieving that in really difficult situation. And one of the principal findings of her research has been the critical need for well-developed common standards at both a legal but also at a normative level, as well as common standards to practice, of practice to guide the application of victim participation. So that's why the theoretical work is informed also by the idea about how it should play out in practice. And guided by the research and with a view, of course, to advancing the role of victims in international criminal proceedings, we embarked on this very project, which was generously supported by the UK's Economic and Social Research Council. So we worked on these host events that Regina talked about at both The Hague and in Oxford. And these events allowed us to really bring together very distinguished practitioners and scholars to have conversations about what has been done in the past, what should be done, and how to realise those more normative goals of victim participation. And it's in that spirit that the idea for this publication emerged. And it's always really nice when you see something coming out the end of a long story where people have been working collaboratively together. So I'm really delighted to see this professional publication that will continue to pave the way for a valuable contribution to the strengthening of the ICCBA's institutional capacity, and also its work with training victims' legal representatives. And the publication, of course, will outlive the project itself, as they always should do. So Victimology Victims, they've constituted a significant part of the work that Regina and I and some of our colleagues at Oxford have done, looking at very different ideas about victims' role in the system, different types of victims, victims of violence in the home, victims of sex trafficking, victims of murder. So different projects we've done, and of course more recently looking at different notions of victimization, such as people who are deemed to be illegal migrants in the UK and being victimized in the system, or people who are wrongfully convicted being seen as victims. So there are very different ways that we have conceived of victims, but often when we come back, it's about their role in the system and how we should try to make the system less cruel, less difficult, less daunting for those people going through that process. And as I said before, the development of victims' rights in the UK really goes back to the 1980s and the 1990s. And it's a product of a broader movement of parallel advancements in both domestic, but also slightly later in international legal systems towards this greater acknowledgement of victims' rights. And these movements came about because of the research that we'd done in the past, which showed that victims felt displaced from the process, that they showed that they felt that they didn't have a voice, that they felt marginalised, that they felt re-victimised. So these are really important questions for international criminal justice, just as they have been for for domestic criminal justice systems. And of course, you know, 1985, it seems like a long time ago, but in the history of criminology, it's not so long. And we had the United Nations Declaration of Basic Principles of Justice. You know, this idea that there should be both service rights, the rights of victims to expect certain things to be given to them throughout the process, but also process rights, rights to allocution, rights to have a say, rights to have a role to play at some stage or other. And that's been reflected in the work that I've done in Oxford, but it's also been reflected in the wider work that Regina has done in Cambodia. So on the small stage and on the big stage, we see the same questions arising, and then we see the same approach to trying to work out what are the best answers to those questions. And of course, the International Criminal Court is there, the first international criminal tribunal to endorse victim active participation by recognising victims as participants. And that trend has been reflected in other courts that have followed the establishment of the ICC, such as the ICCBA and others. And so we really hope that this professional publication will make a lasting and a valuable contribution. It really does bring together knowledge and experience shared by participating practitioners and scholars. And it's therefore the kind of first of its kind to bridge the gap between research and practice in an area of victim participation in international criminal justice. And so we want it to strengthen the ICCBA's institutional capacity, as well as, well, really as an independent representative body of counsel, and to further advance the legal representation of victims at the ICC. And it has enormous potential to do that because, as I said before, all the key issues that you'd want to think about if you were thinking about the role of victims are covered in these very thorough, very thoughtful chapters, many of which draw on real life experiences of trying to do justice to victims in the system. So just really well done. Very proud to have played a small part of it, and I hope you all get a chance to read it. Thank you.
Well, I guess it's me now, and I'm not going to add substantively to the introduction of this magnificent publication. You have some of the authors here to consult with, and both of the editors and Professor Hoyle, who have introduced the work in great detail. The first thing that I have to say, as the fourth president of an association which has not yet had its 5th birthday, is that it is a scarcely credible honour to be associated with this project, and in particular to see the insignia of the ICCBA sitting at the top of the invitation to this event alongside those of the UK Economic and Research Council and the University of Oxford, the most august and respected educational establishment in the world. In this collaboration, in many ways, the ICCBA is the baby, and certainly in terms of its age and experience. And it's a child whose gestation period has been relatively long and complex. It's hard to believe that the association was not created concurrently with the International Criminal Court itself. And for a number of years, those who appeared before chambers of the ICC representing accused, victims, states, amici, and other interested parties had no representative body or collective focal point. Nowadays, the membership of the association numbers about 340, and it represents those who are on the lists of counsel at the ICC and those who act in junior roles as support staff. The association is not like its counterpart at the ad hoc tribunals, the ADC, an association of defence counsel alone. but rather one which welcomes both those who defend accused persons as well as those who represent victims and other interested parties in the proceedings. Its membership, moreover, embraces those who are employed directly by the court itself within the offices of OPCV and OPCD. The importance of a bar association to developed judicial systems is well-trodden ground, but perhaps I might just highlight the long-term objectives of the association within the framework of the court. It will try to ensure that the bar, through being self-regulated, is independent of political interference. Secondly, it will try to ensure that everybody who practices before the court plays by the rules. Not just that people don't cheat, but that they're insured, pay their subscriptions, and observe currently accepted standards of behaviour. Thirdly, its objective is to ensure that those who represent persons who appear before the ICC, whether defendants or victims, are up to the job, that they have appropriate qualifications, appropriate training, and continuing professional development. Fourthly, it provides a forum for practitioners to exchange ideas, much as has happened here, and experiences both within the membership of the bar, but also with opponents, the judiciary, the courts, administrators, and academics. There is, at the end of the day, no substitute for experience. Fifthly, it provides a voice for those who fall outside the central structure of the court in relation to things such as legislative changes, legal aid funding, and basic lawyers' rights. On the other side of that fence, the bar presents as a focal point for the court to seek the views of independent professionals who use it, and it presents as a genuine interface for collective bargaining. Lastly, but not leastly, a bar offers a pastoral element to its membership, indeed even a social one. For all the merits of a training course, the drinks reception at the end of them is often just as important to people who are a long way from their homes and families. The progress of the ICCBA in terms of its position within the court structure has been rapid. At its last meeting, the Assembly of States Parties recognised the ICCBA as the bar association of the ICC, and during its review of the court's practices, the independent experts panel received considerable input from the association and reflected that input in its recommendations. Of course, a goodly portion of the independent expert review is devoted to the many issues concerning victim participation in the proceedings of the court. And not even the greatest champion of victim participation would venture to suggest that it has been a success thus far at the ICC. The instant publication, as you've already had highlighted to you, discusses many of the matters considered by the panel of experts and a great deal more. It is a project of admirable scope and, if I may say so, exquisite timing. Well, perhaps exquisite is a little hyperbolic. It might have been a good idea from a PR perspective to have launched this publication before the university released its COVID vaccine test results, but c'est la vie. This publication is another big step forward for the ICCBA. It is the first work of its kind to which it has lent its name, and on behalf of the whole membership, I wish to reiterate the pride we feel at being associated with it. We look forward to further collaboration in the future. It only remains for me to congratulate the contributors and the indefatigable editors, Greg and Ina. You have to try doing this to realise how much hard work it is, pulling together a publication of this sort. It's not just hard, it's frustrating. You spend your whole life trying to cajole, even bribe people into contributing to the work only to be let down. And they know that from me. My thanks also go to the sponsors, the University of Oxford and the UK Economic and Research Council. I hope you all do read this book. It's a fine piece of work, and I'm proud to commend it to you.
Thank you very much, Peter, for your very kind and most exquisite remarks. We are most grateful. And to you, Professor Hoyle, for all your substantive remarks regarding the research that University of Oxford has done, and also to highlight the importance that this publication has with regard to advancing research that is impact-oriented. And we hope in that sense that this publication will be lasting and a valuable contribution to both strengthening the institutional capacity of the ICCBA, as well as other institutions and other courts who may benefit from the knowledge and the insights of practitioners and scholars grown from theoretical and jurisprudential developments of victim participation at the ICC. Now I would open the virtual floor to other panelists, or actually in this case we have all the, not all, but some of the contributing authors who are participating, as well as those who are participant registered for this event. Gregory, I noticed that you have written to Paulina and Luke. So if any of you would like to speak, please, Dominic will assist us and facilitate for that.
Thanks, Hina. There's also, I think, Megan Hurst potentially standing by. Paulina may have left at this point. And I understand Luke and Anne Michel's are both here as well. Megan, are you there? And perhaps Paulina has left, I understand. Thank you for that update, Dominic. And while we're waiting for someone, Ellie Smith has joined us but has to go. I understand that Megan may be in a position to join us. I'm not quite sure. I'll just chime in for a second. Peter and Dr. Hoyle, thank you so much for the kind words. What you made me remember is that most of the authors gave recommendations and suggestions, and so I think this is a really forward-looking piece as well. I got a statistic which I think I should share. The council support section noted that there are 767 lawyers on the ICC list of counsel that have indicated their willingness to represent victims. And so it's quite a large list of counsel. Very few people have actually managed to stand up in court, and we've managed to have some of those impressive lawyers help formulate really excellent articles here. Megan has put into the chat, she doesn't have any remarks prepared. Would you like to just explain the inspiration for your article, just rather informally? Or any of the other, Anne or Luke, if you'd like to chime in, that's okay too. We're standing by. Megan, I think you're in if you can join us. And sorry to put you on the spot if we're doing that. The floor is yours if you can, Megan.
I can. Just 1 second. I'll try and see if I can get my camera functioning.
We can hear you at least.
Hi.
Thanks. The floor is yours.
Thanks. I didn't prepare any remarks. I can say a few things briefly about what was behind our chapter if it's of interest. I had spoken at the first event, which Ina and Greg organised a couple of years back. And it was really, I think, a bit of a venting of my frustrations about the fact that we need to do more to improve the quality of legal representation at the court for victims. And I should say I include myself in that category of people who could use some assistance improving their work. Really, the chapter attempts to look at why this is a challenge and what we could do about it. I think when I gave the presentation a couple of years ago, I said that I felt it was the elephant in the room. As counsel, we don't like to point the finger at each other in a collegiate environment and say that people aren't doing a good job. So it's difficult to discuss. And it doesn't, I think, necessarily need to involve putting the blame on individuals. And the chapter, which I co-authored with Sandra Sayuni, who unfortunately wasn't able to join today, we tried to look at some of the reasons why the quality of legal representation for victims hasn't always been as high as what we would hope for. And many of those things are structural. You know, this is it's a new phenomenon, and even though it has its roots in some systems for representation in different domestic systems, it is a sui generis system. And on top of that, we are trying to bring in practitioners from the situation countries who maybe aren't international criminal law practitioners. The case law of the court is constantly evolving. And, you know, there is, unfortunately, or there has been, I think, a lack of sufficient support from the court in terms of resources and technical assistance for those who try to go about being victims counsel. So there are a number of kind of systemic and structural challenges. And we did also look at, you know, the things that might be considered kind of individual failings and how you would correct them. How do you ensure that there is monitoring of what's going on and means to intervene in a way that doesn't interfere with the independence of counsel, which is so important as well. These are all really big challenges, and I don't think there's any easy solutions, but I really believe it's a very important issue to discuss, because we've had too many cases at the court, I think, where victims are not receiving the quality of legal representation that they deserve. And the lawyer is essentially the bridge between the victims and the judges. So if that bridge is broken, the mechanism isn't working. And I'm really happy that Peter's here today on behalf of the ICCBA, because it nicely brings me to what a lot of our conclusions were in our chapter. And Peter knows, I think, that these are my thoughts, also as a member of the ICCBA Executive Council, that there is going forward and in the long term a really important role for the ICCBA as a professional body for counsel to help counsel to raise the standards of their work by providing them with the training that they need, by advocating on their behalf to the institution in terms of the resources and support that they need, and perhaps to playing the sort of role that professional bodies play at the national level in terms of stepping in the event that there hasn't been professional conduct, because the ICCBA would be a body that counsel should trust to be independent and to act appropriately in that regard. So we have, you know, we've tried to set out some concrete recommendations in our chapter as well, but it is a really big, challenging topic. So it's going to take some time to improve these things, and the chapter is really intended as a starting point, I think, to get people talking about this more.
That's really helpful and explains a little bit of the history there for it. You made a recommendation about making software for teams, about a code of professional conduct. And is that something for ICCBA, or any other thoughts? Or maybe there's questions out there for Megan. If anyone has a question for Megan, put it in the chat for as long as she's willing to stay with us.
I can say a couple of things about the code of conduct. You know, it's been one of my frustrations that the code of conduct is such an, along with other documents at the ICC, such an inflexible document. I can understand that at the time it was drafted, victim participation was really an unknown quantity, and it was difficult for the drafters of that document to anticipate what the challenges would be that would arise in practice. But we now have a document that really hasn't been amended, you know, in the life of the court, and we're seeing professional ethics questions evolving that are specific to victim participation. And for those of us working in this field, we don't have an answer. I don't really expect the Assembly of States Parties who regulate, who have control over amending the Code of Conduct, I don't expect them to be the best place to grapple with these issues. And it's our recommendation that instead of trying to get amendments to the Code of Conduct pushed through, that we could accept that the Code of Conduct actually hits the key principles, and that the ICCBA perhaps might be able to flesh out some of those key principles with guidance. I know in the jurisdiction that I'm qualified in England and Wales, we have a code of conduct that starts with principles, and then it has, you know, more specific guidelines that are tailored to specific situations. And I think that there could be a role for the ICCBA in helping practitioners with something like that. Down the track as well, it would also be great if the ICCBA could eventually be in a position to provide something like a helpline, so that when you have a problem where you don't know what your ethical obligations are on a particular issue, that you can actually go to somebody who has experience as well and ask them what their views are. Regarding technical tools, very briefly as well, I mean, it's been really frustrating to me to see coming into the court that you can be asked to represent 2,000 clients and you're not given any tools for how you're meant to manage the information relating to your 2,000 clients. And as I understand it so far, the only tool which is being used at the court is Excel, which, you know, anyone who's tried to have a document in Excel with 2,000 lines of data in it will know, particularly if you have 5 or 6 people in your team all working from the same document, it's pretty unworkable. So we really do need custom tailored software that will actually allow legal representatives to appropriately store the information that they're collecting and using in relation to their individual clients and their activities.
Great points. Thank you so much. You've got so many clients. How do you zealously represent them? And that's a code of conduct. And you've got so many clients. How do you keep track without those tools? So thanks for bringing those points home. Really appreciate it. Those are really good. I'm not sure if the others want to chime in or pepper Megan with more questions. I'll invite Luke next.
One out of left field here, Megan. I mean, you and I spent an hour in front of panel 2, and we submitted quite a lot in writing about victim participation and reparations. I just wondered if in a couple of paragraphs you could give us your reaction to the panel's recommendations about victim participation and reparations.
Thanks, Peter. I was somewhat disappointed by the victim participation section of the expert report. I don't see anything in there which grapples with the real challenges relating to legal representation. There is a passing recognition, I think, that legal aid needs to be improved, but most of the legal aid recommendations are directed at Defence Counsel. There is no real grappling with the issues that I think we had included in our submissions about how you deal with the problem of ensuring that victims have some say in who their counsel is, but also how do you deal with that in a scenario where you have thousands of victims, and how do you find a balance between efficient collective representation but giving victims a choice. I didn't see any great solutions in the experts' response to the other issue we had flagged with them, which was the application process. And it felt a little bit to me as though the experts stepped back from that. we had said on behalf of the ICCBA that there needed to really be some consideration of whether this individual application process is necessary and useful. And I see the experts dismissing that with the statement that the application process is important to victims. That's something which I think we need more research on. It's not been my experience. It's not the findings of the empirical studies which I have seen which have looked at the question. So I think we're falling back on assumptions without having actually looked into the questions. Finally, I think that the experts kind of come to the conclusion that there are a lot of outstanding questions in relation to victim participation that need to be resolved through a proper study for reform and a proper reform process. I think what is absolutely essential in that reform process is that victims' counsel with experience are actually included in that process, and that means I think there needs to be a seat in the process for the ICCBA. So I'm hopeful, kind of to try and finish on an optimistic note, I'm hopeful that it's not been a failure and that actually all we've seen is that the can has been kicked down the road a little bit, but I think that it's still then, I'm still anxious that when that process happens in the future, that it's going to be a useful process and that it will actually invite input from victims' counsel. And ultimately it needs to also find a way to try and get input from victims rather than just, as we've seen so many times, people kind of speaking as though they know what victims want or acting on assumptions without actually thinking about how they can find out what the victims really want. I'll stop speaking now and let someone else have the floor. Thank you.
Thanks, Megan. Unless there's an objection, Luc Valens joined us. And maybe you could tell us a little about your inspiration, collective reparations, considering we've got 37 minutes left, I think.
You hear me? Hello, Gregory. Hello, everybody. Thanks for giving me the floor. It was a really pleasure to cooperate in those seminars we had, and also to have this work made together that we present today. I think there's really a big need for training, but also even for trained counsel for exchange of experience and reflection on what we are doing, because it is so new. And where the participation in the criminal process is still something that's part of the experience of a lot of counsel, certainly in civil law countries where you have an experience of working for victims as a civil party. But when it comes to reparations, and especially collective reparations, it is really something absolutely new. And even the court is struggling with that area. We have a practice which is not really not what the drafters of the Rome statutes and other instruments of the court had in mind. If you have a look to the rules of procedure, for instance, you see that those drafters had still in mind participation of individual victims and reparation of individual victims, even if there is a possibility for the court to order in exceptional circumstances to order collective reparations. But there is nothing in the text about what's the meaning of collective reparations. I think in the mind of the drafters, it was seen as community-based reparations, which is also not exactly the concept that is developing now at the ICC. In fact, certainly in our case, but from what I I hear about other cases. Of course, there are not so much cases where programs of reparations started already, but the court seems developing a concept which is some mix of collective and individual reparations, not really community-based, but still the court stresses that the reparations should benefit to the victims, to those who suffered from the crimes committed, and not exactly communities, although there is no exclusive, but certainly in cases of child soldiers, for instance, where the community was not victimized as such, but where the community was more or less supporting the responsible for the crimes. So that's a quite difficult situation. As at the other hand, there is some reluctance at the side of the court to give individual reparations to a certain category of victims. In the Katanga case, where victims were people who had their relatives killed, their houses destroyed, etc., you have a more clear victim concept, and it's obviously more easy for the court also to afford individual reparations, although even in that case, the court opted for collective reparations. With child soldiers, which is the case in Lubanga, but also in Taganda, it's not already, it started already, but it will start. I mean, the reparations, if the conviction is confirmed, you have a category of victims who was involved also in the in a form of crimes, a form of participation in the crimes, even if they were forced to do so, even if the result for them is at least so heavy as to be in another situation of victimization. But these are complicated situations, and counsel are not at all prepared to it. Not prepared legally, and not prepared also professionally, because it's not working with certain categories of victims, especially in a situation where you have new frustrations provoked by the procedure itself, frustrations you have to cope with. It can be very difficult to have to handle that, and of course you have to handle it as a team. Your counsel are not alone. In cases where you have 1,000 victims or more, you have not the lawyer, but you have to organize a team with people on the field, with intermediaries, and as such, it's a concept to be developed. How can you organize people? How can you organize transmission of information from the team to the clients, from the clients to the team? How can you bring a large group of victims to a common position or a majority position when it is necessary to give a position of the victims? For instance, in a discussion we had, if there's an application for reduction of the punishment of the convicted. Well, victims are invited to give their opinion on that, but there is no one opinion of the victims, of course. Some victims will consider that that could be a way to negotiate something with the accused. Others will consider that it's totally unacceptable, and the court will ask you to give the views and concern of the victims. So organizing all those things is something to be learned, and I think most of the teams, they learn it by experience, but there is very few exchange between, and there is no well, I think there is space for more academic work also to develop such new practice and such new concepts. Another aspect, for instance, and then we stop, is that in a especially collective reparation program, legal representatives are invited to participate in the program, not only in the discussion on how to organize such a program. This first discussion is even a discussion that is where the defense is involved. Should there be an individual reparation program or a collective reparation program? But once there is a final decision of on the amount that the convicted person will be responsible to assume, there is no longer the same involvement of the defense. The convicted person can be involved in a reparation program, especially if he or her, if he wants to be involved. Excuses from the convicted person, a attempt to participate in the reparation itself could be a very positive involvement of the defense, but also for the defense, something like that is quite new, I think. For the victims, the court is asking us to assist also the trust fund to identify beneficiaries. So it means that we are not just representing the clients who contacted us, but we are supposed to, and it's certainly the case for OPCV, but also for other legal representatives, are invited by the court to assist the identification of the beneficiaries, to assist them to draft an application form, even if it is not the same application as it was conceived by the registry, but it's a form of application to participate in the program. So all those things are completely new, and I would certainly be in favor of a more important seminar of exchange and study on these new practices that are developing and that can be compared to some existing programs that were ordered by human rights courts and so, but it's still not the same. It's not just a fund or organization that is charged with the development of an assistance program, but it's still a judicial procedure. There's still a strong control from the chambers, and there is still an important role also for counsel. Voilà.
Thank you so much, Luke, for all your remarks on collective reparation. We have received a question from Dov Jacobs, which is addressed to you, but it's also open to other panelists. Isn't there a moment when the idea of collective reparations stretches the concept of individual criminal responsibility beyond recognition, and it does not show the limit of ICL as an adequate forum to deal with reparations in the case of mass atrocities?
Well, for the victims, there is a problem indeed that the reparations are connected to the decision of the criminal conviction. You can have some facts established in the criminal phase and others not. And that can create some kind of discrimination between victims. There is already the choice of the prosecutor to prosecute some events, some crimes and not others, although similar crimes have been committed maybe just some kilometers away of that to another group of people. But if it wasn't discussed in the court, those people will not receive reparation. It's of course that there is the assistance mandate of the trust funds, but I have not a clear-cut opinion on that. But it's worth to think on it, that reparations. Every victim every person who was victim of a crime has some right on reparation. And of course, it's completely normal that the convicted person is only responsible for his part of his contribution to the crime. But when in practice the crime is repaired by a trust fund funded by the international community, by some states, by some sponsors, it's not normal that the reparation for some victims depends only on the choices of the court. You have it also the other way around, seen from the side of the participants, and in particular, you have two people who will probably be convicted for the same crimes, Lubanga and Latanga, because Lubanga was convicted for crimes he committed together with Bosco Ntaganda, and vice versa. But there is only one kind of harm, and the victims of both are the same. So it's there is no real concept at the level of the court, and even no coordination between the chambers to see, do we start with the harm and then go to a conviction of the accused, of the several accused, to pay their part of the harm or their part of the reparation, or do we handle that completely separately? So my feeling is that they are going the way, organizing a collective reparation program for crimes of Lubanga for some years, and then later on they will start maybe a new program with, and then the question is, can the same people have a double reparation, or how is the relationship between that? In normal cases, reparation starts from the harm. If there is, for instance, an important accident, let's say a train accident or an explosion of a factory, the first step will be to organize some reparation to all victims. And the second step, when it comes to the conviction of some responsible for what happened, then the court will decide what will be the contribution of each company or each convicted in the global cost of reparation. But very often the reparation will already start immediately after the crimes. The insurance companies or even state-funded funds will organize a reparation before there is a conviction, which and the responsibilities can be determined later on. The advantage of such the system is that people have not to wait 10 years before they have some view on reparation. The Lubanga case started in 2006. So he was convicted to 14 years. He's already liberated, but the reparation program is still to be started. So those questions are to be discussed.
Maybe that's a good spot to end there, Luke. Thank you so much. Megan, anybody else wanted to chime in on that question from Dove? Collective responsibility. Luke's made a really interesting point in his article about interim reparations. And I think that's a really interesting way forward. And this relates, of course, to the assistance mandate. That comes up in a lot of articles.
Yeah, I was interested to hear what Luke said, because my instinct was exactly the same answer, really, that from the victim's perspective, there's a huge question of fairness. And I think it surprises people sometimes because people expect us to say reparations at the ICC is a great idea. But there is a real problem with fairness, because almost inevitably we're looking at crimes which have happened in a much broader context of other atrocities, and it feels you're already dealing with the context in which in your work you're constantly confronted with the fact that there are so many victims being excluded by virtue of the prosecutor's choice of case. And so sometimes it feels like adding insult to injury that those who've been excluded not only didn't get to have a say in a case on the international stage, but they also then don't get to have reparations. And what I wanted to add maybe to what Luke said that is maybe an interesting comparison to look at is what's happened in Cambodia at the ICCC, which is a move towards something a little bit more like a trust fund model, a trust fund assistance and support mandate, maybe in the sense that the responsibility for reparations was somehow disconnected in case 2 from the liability of the accused. And what that enabled was for reparations projects to be implemented from the beginning of the case. So it wasn't necessary to wait for a conviction. And of course, there are a huge number of shortcomings in this mechanism, this new reparations mechanism at the ICCC as well, because there wasn't a trust fund, you know, and the NGOs and civil party lawyers had to go finding the money for themselves. So that's a huge problem. But I think the idea of taking a broader approach to reparations, disconnecting it from the conduct of the accused and the accused's liability is useful in a number of ways. You can address that fairness issue, but you can also address the timing issue and get things started earlier. And I also think what's been interesting at the ICCC, I came in here in Cambodia fairly late in the piece, but what I see is a reduced level of antagonism perhaps between the defence and the victims, civil parties, in respect of reparations, because it ceases to be a contest between the defence and the victims once you take the liability of the accused out of the picture. I'm not sure whether we've done enough research yet on how the victims themselves feel about that, and whether they feel that they're losing something if the reparations doesn't come from the guilty individual who is eventually convicted. But in this realm of work, we are always, I think, looking at victims who have long ago resigned themselves to the fact that they're likely to get very little. So it might not be everything that they hope for or wish for. I think we should be aware of what they would ultimately wish for, but where it enables a fair process that gives access to more people and sooner, I think it's definitely worth looking at.
Thank you. Ina, I was just going to suggest we hear from
yes.
Megan, if that's okay.
But there is a question following on that from Erin Rosenberg. It's actually addressed to Luke, but I'm sure Megan can join as well as the other panelists. Are you arguing for reparations liability determination to occur at the situation level, meaning at the time when multiple perpetrators have been tried, which would occur after the reparations implementation, still on a case-by-case basis, but funded upfront by the Trust Fund for Victims? Very interesting contribution, Erin adds. The question is for Luke or Megan, whoever can contribute with an answer.
Thank you, Ina. Yes, there is even a follow-up comment I see from Franziska Eckelmans also. TFE is running assistance programs since 2008, having more than 100,000 beneficiaries, etc. Well, it's exact that the assistance programs are going on, but I don't understand very well why there is such a Chinese wall between reparations and between assistance and reparations. I think that the victims doesn't really feel the difference. They see assistance programs as already a form of reparation of their harm, and it is actually already a form of reparation. And at the other hand, when the reparation program starts, there is no longer link with the assistance that took already place. Maybe at the level of the trust fund, there should also be some reflection on the relationship between those two concepts, especially as the chambers asked explicitly the trust funds to complete with assistance from the assistance budget, where the reparation is not effective for certain categories of victims. An example, for instance, in the Lubanga case was that the accusation of, and there was no prosecution for sexual abuse, as a lot of child soldiers, practically all female child soldiers, but also some boys, were victims of sexual abuse and sexual slavery. But in the Lubanga case, it was not part of the conviction. It is part of the conviction in the Taganda case for exactly the same people. So the court decided that as there is no conviction for that crime, there cannot be any reparation also for that harm. But at the same time, invited the trust funds to accept victims of sexual abuse in the framework of a recruitment as child soldier would be taken up in an assistance program. But I think it should be possible to have something much more smooth, where the harm is repaired without asking the first question, Is it in the judgment? Is it not in the judgment? Should we wait 10 years later before we can help victims? And that's indeed the whole discussion. In my view, there could be a form of assistance, reparation, interim release before even there is any conviction. But it's also logical that if there is a conviction, that you ask the convicted person to take either, if the program is still going on, to contribute with his own assets, for instance, or to refund even the program of the trust fund. But all these questions are open, actually.
I'm just trying to be mindful of the time, and I'm not sure how much we can go over 3:30 local time. If we could hear briefly from An, and then I know that Nilmani Verma's had her hand up from a long time, and if we could address that, perhaps have Anne, then Lorraine Smith, just a couple minutes, and both of you touch on some of the issues Luke's already been talking about. So feel free to chime in on what's already been put on the floor. And thank you. An, feel free to join us with your video when you can.
Hello, everybody. And thank you for having me as a panelist. And I'm very much enjoying the discussion. So I will be brief looking at the time, but let me just start by also congratulating all of you, Ina and Gregory, for the fantastic publication. I think you can really be proud in bringing together these different perspectives. And of course, I'm very pleased to see that there are two contributions by psychologists in your book, which I think is essential if you want to talk about the relationship with victims. You can't, in my view, you can't talk about it without addressing the psychological side. So that's also what I try to do in my contribution. And just very brief, I want to go back to what Megan, the picture Megan painted in the beginning is that, and because I remember as well very well the event we had in 2018 and the very constructive discussion. But it was, what I remember from it was this, very much this feeling like this is such an emerging field and it's such an uncharted territory and so much still needs to be developed. And these legal representatives are out there a little bit in the dark with these ambiguities, etc., that are still there. And that made me reflect about also in part about how the whole element of psychosocial support in international criminal justice developed was also very much an emergent field. And the last 10, 15 years, we did a lot of work in kind of fine-tuning it, putting it in a framework mainly. So I thought that could be an inspiration. But also I wanted to focus on the relationship that legal representatives have with their clients and draw indeed a parallel between that relationship and the relationship psychologists that the ICC have with their clients, because I think there are some significant parallels. There are, of course, enormous differences. Psychologists and lawyers think quite differently, but I think it's important to look at the similarities to actually push the debate forward. And in terms of similarities, I think both lawyers and psychologists have to listen to the stories of their clients. And often these stories, in the case of the ICC, are very dreadful, difficult, traumatic stories, which we have to all take in. We also have to manage the relationship. We have to manage the boundaries, manage expectations. I hear a lot the discussion, very interesting discussion about reparations and the expectations that are created. So that the expectations of what does it mean to be involved with the court, you need to work on that and you need to communicate these boundaries constantly. And of course, last but not least, I think both for psychologists and lawyers, I think psychologists find it easier to admit than lawyers, but it is a draining thing. It's draining to work with victims, and we need to be aware of that. Otherwise, we lose ourselves, or we're no longer good professionals. So, but most importantly, in my view, the relationship between these professional groups and the victims and witnesses is critical to ensure that victims gain a sense of control over their engagement in the process, and that they experience their interaction as meaningful and dignified. And so by focusing on the relationship, you can make sure that it's meaningful, dignified, and professional, but also this is, in my view, a way to make sure that the promise which is there, that it is also restorative, this interaction, that it can be fulfilled. And if you want to do that, and I think that's what we all want eventually, that there is also a restorative element to this, you need to look at the relationship that you have with your clients. And I know it's not a usual perspective, but I think it's an important one to take in consideration if you want to develop this field further. And just to say a few elements, I don't want to take too much of the time. I invite everybody to read the piece, but just a few elements that I highlight is that what psychologists do when managing the relationship with clients is they focus very much on boundaries. And boundaries are based on standards, on frameworks. The legal framework is for us within the ICC very important, which sets the limitations of what we can do, but also an operational framework and an ethical framework. So these boundaries are really important because they protect us as psychologists, because it protects you, it allows you to show empathy to your client without being overwhelmed, etc. The usual things psychologists do. Or to create space for reflection, etc. But it also, most importantly, the boundaries protect victims, because they create a sense of control over the process, and a loss of control is what is key when for many victims, especially those who suffer from trauma, and I think the majority of them do, is the loss of control they experience during the trauma and in managing their symptoms. This is, so you need to do everything you can to give them back this sense of control, and you do this by being predictable, by being communicative, by managing expectations, whatever your role is, whether it's your role as a psychologist or as a legal representative. So I think I focus on that very much. So the clear framework and managing and actually an invitation to think more about this relationship. And I hear now again that the situation of a legal representative representing thousands of victims, it has of course had its own challenges. Just in terms of recommendations, very, very brief, is that, yes, Gregory, you summarized it well. I always say that I think lawyers need more training. Because I really do think it would help to develop the field forward and to help lawyers, to be legal representatives, to be better at managing this relationship. And training should involve training on victimization, on trauma, and it's there. It's already offered at the ICC, just not enough. It should be more. But to foster an understanding of the psychological meaning of the relationship, and then come to also to understand the impact it has on the legal representatives themselves. In addition, also something that we often stress as psychologists, but I can't stress enough, is to give lawyers access to self-help or to self-care tools. At first, to create an awareness about the heaviness of this work, which people very often underestimate, but also to learn how to deal with it. And I think the ICCBA, in my view, can also play a role there by setting up peer support and more connection, and making sure that legal representatives work less in isolation, but more in a community where they can exchange among colleagues. Also, I think the court should, it was already mentioned by earlier contributors, but I think the court should absolutely pay explicit attention to the development of the ethical framework, and the ethical framework, but also for me, the ethical is often translated into an operational, very clear operational legal framework and an ethical framework, that there is a clear list of do's and don'ts for legal representatives, which will help both the victim and the lawyers involved in it. And last but not least, and I think it's a bit of a difficult or a more challenging point, and it certainly needs more reflection and research, is to strike a balance between the individual and the collective, because as Luc very, very well put, there is such a focus on the collective reparations, collective representation, etc. But I, as a psychologist, I also see very much the individual need of victims. And I think there, And I don't have the answer to that, certainly not. But I think it's more an invitation to think more about this individual perspective and to strike the balance. This is, I think, in a nutshell, what I wanted to say about my paper, but please read and you will find out more. Thank you very much.
Thank you so much, that's really, you've enticed us now to read more. And the training you talk about, the first day we'll be reading your article, just so that we all know. So really well done. Perhaps I can give the floor back to Ina, Professor Hoyle, Peter for a last word. I think we're already 1 minute over at this point.
Yeah.
So thank you for the authors that joined us. Thank you for that. Lorraine Smith is unable. Thanks for those who put a question in the chat. I know Ms. Verma had a hand up, but I haven't seen a question come back. I'll chime out there. Thank you.
I just wanted to add a very quick concluding remarks by thanking all of you for your valuable contribution to this discussion. It's been truly insightful and thoughtful. And I wanted to let you know that the publication has been added to the ICCBA and Oxford Faculty of Law website. You can access it at any time. And I thank you all for your contribution to this project and to this publication.
So with that, we say thank you. Peter,
I think it's been a magnificent debate. It's a fabulous achievement, and one I'm very proud to be associated with. And I want to thank everybody for their contributions today and to the book.
Professor Hoyle, can we give you the last word, since you helped us get this far?
Just too much responsibility to give me the last word. I really just wanted to reiterate that I was very proud to be associated with it, and to thank the two contributors, Megan and Anne, who came on and just talked so eloquently and interestingly about their work, and that for me was a really nice contribution. So yeah, particular thanks to Megan and Anne for being dragged out of an audience of various other people and just being so eloquent and passionate when they haven't had a chance to prepare that. So very impressive, thank you. And thank you to Ina and Gregory for all your hard work.
Thanks. And I think, you know, this is all this is the project of Ina. So thank you. We would not all be here without Ina's leadership and connecting, bridging the gap, bringing us all together. I'm just, you know, fixing commas, and it's really, thank you so much. Well done. So we sign off at that point.
Thank you.
Thanks, everyone. Dominic, thanks for helping us on support and all. And thank you for all the viewers. Appreciate it.